Joining me to discuss what we've just listened to so we can analyze it is Seth Berenzweig. He is in the state of Virginia. Seth, I want to start with you. You are in the nation's capital, and you are very familiar with the High Court here. What stood out to you, first of all, in this first argument that we heard today, either from the justices' questions or from either side's argument?
Sure. So I think that one of the things that's so fascinating about this case is that it is such a critical constitutional issue at a historic, momentous time. We're really dealing with something that cuts to the heart of how the election will function just a few months out. And I found the arguments to just be fascinating and the justices' questions to be equally fascinating. I think that the core issue in this case is the battle between federalism and constitutional individual liberties to vote one's conscience. And the state is trying to lay out the path, what I would call, what they would try to suggest as a easy constitutional path to demonstrate that the power of appointment is the power that goes much beyond that. And as Justice Sotomayor was very effective in pointing out in response, the power to appoint does not necessarily mean the power to control. And in fact, what's really just so fascinating in this case is that the Constitution is really somewhat silent in terms of really the core issues in this case. So one of the really difficult things that the court's going to have to wrestle with here is the balance between federalism and freedom of political expression and individual freedom to cast one's vote as they feel their conscience requires under, among other things, the First Amendment. This will have a direct impact on the election. If you thought that the election in 2016 was going to be controversial and tight, we know that it's going to be at least that much so heading into November. So a crucial constitutional case at a very important moment in the history of our country.
Yeah, and this has happened in our history, but it really hasn't mattered. You know, at the end of the day, these rogue votes have been accepted, but because they didn't change the outcome, it really hasn't been a factor. But to your point, and which was brought up in the arguments, that could change. You don't know. It could be this year, it could be 10 years down the line. At some point, those few votes that go the opposite of the state's majority make the difference in an election. One of the things that Justice Breyer brought up, which was interesting, he argued that, well, doesn't Congress have the ultimate safeguard already in play? They don't have to accept a rogue vote if indeed it got to that point.
Sure, absolutely. And, you know, if the founders intended to have additional constraints on this, then they certainly could have put that in the Constitution. Now, of course, historians, constitutional historians will point out that, you know, of course, hindsight's 2020, and people at that point, there was a crack in their crystal ball. They never knew that these issues would precisely come up hundreds of years down the line. But, you know, at the end of the day, I think that the court's going to have a difficult time coming down on the side of individualism and individual freedom to vote their conscience. But, you know, you really have a direct battle, if you will, between federalism and the First Amendment. There are some 10th Amendment overtones here, although I found it somewhat interesting that counsel for the state of Washington, you know, didn't exactly waive that argument, but kind of gently stepped away from it a little bit. And I do think that the 12th Amendment argument on their behalf is at best vague, because I don't really think there's an answer there either. So the challenge for the state of Washington is to say there's a constitutional path, just walk with us down that path. It's all there, and the power of appointment is the power to control. And then on the other side, you have the point that the Constitution does not expressly address precisely what's at the core in the issue of this case, and that people have a fundamental right to be able to vote their conscience. I agree that this is really going to go to the core of the fundamental elements of how the election is going to occur, not only at the end of this year, but as you correctly point out, in future years. So these are cases that are not only constitutionally critical, but that are going to have a very momentous point within the historic context.
Yeah, absolutely. And we're going to see that 10th Amendment argument in the next case, Colorado versus Baca. That is part of the state of Colorado, the case in Colorado, that argument. We're going to take a break. Joining me again from the state of Virginia is Seth Berenzweig. And Seth, Samuel Alito is quite the personality. You usually know where he is going. Some of the other justices, of course, the swing votes, on the court. Those are the ones that really the folks that read the tea leaves are focusing on in arguments like we're hearing today. What is your take on who in today's arguments, who are the justices we should be listening to? Who will decide one way or another, going with the states' rights or the idea that the federalist mentality is in charge here with these faithless electors, these electors who have gone against what the state's majority has told them to vote? Who should we be listening to when we listen to this next case, Colorado v. Baca?
You know, I always find that question to be always so fascinating when you hear each of these arguments with the Supreme Court, because just when you think that you knew who was going to be the swing vote in something, when you start to hear the context and textures of the questions that are being presented, you know, you really start to kind of, get a different flavor. So, for example, in the hearings yesterday, regarding the president's tax returns and corporate business returns, as time went on, you know, you started to see how people were starting to go in a different direction. And it's not like the old days where you kind of knew that Justice Kennedy was going to be the swing vote. Now, I agree with your reporting that Justice Alito is quite conservative. I think that listening to what his position in the upcoming argument will be fascinating, because I would initially peg him as someone who would be more interested in the rights of individualism and the freedom of political expression. But then again, as you also noted before the break, it'll be important to see how the 10th Amendment argument flows in here. So I think that it'll be important to hear what he has to say. And frankly, I think it'll be a close call. So hearing how the next questions flow out in the next case regarding Colorado is going to be equally critical.
Absolutely. All right. Well, let's bring in Seth Berenzweig, and Kelly Hyman also joins us now from Denver, Colorado. Kelly, to you first, since you're just joining us. Your take on what we've heard so far in Colorado versus Baca. What stood out to you, either from the justices' questioning or the argument you heard?
Yes, it was a really interesting argument that he made. I think that he made some really good points. That ultimately, it's up to the state. That it's important to think about that every vote counts and every vote should matter. And so, if the elector is a free agent, they're basically not going with the popular vote. And I think that's important to remember, especially with the upcoming election, that a state should allow the people that whoever they want their president, let the voice of the people stand.
Seth, as we wait for the other side coming up next after the break here, what are you listening for? What are you going to be listening for, either from the justices or from the attorney arguing?
Well, one of the things that's always interesting in trying to read the tea leaves here is to really listen intently to the questions from the justices and try to get a little bit into their mindset as to which way they're leaning. And when you really look at it in terms of the first half of this argument, I would say that we've still got a long way to go here, but that Colorado's up against the ropes. I think that the justices, generally speaking, are somewhat skeptical of their position. Constitutionally, Justice Breyer was very interesting in being skeptical of the so-called bribery argument. And I think that really what he was trying to get to is to say, tell me when bribery was ever really an actual factor. And by the way, there's already laws that regulate bribery. And I also thought Justice Alito's argument about pointing out that states could always have better prior clarification of what the actual rules are as the electors come in versus just, kind of going and reaching out behind and bringing them back and pulling them back later was also a very interesting argument. So too early to tell, but I think that Colorado will have their share of difficult questions as well. But a very interesting read as far as the first portion of the argument is concerned.
Yeah, and Kelly, at one point, Justice Kavanaugh said, why do we have the Electoral College, which is a question a lot of people have, is that, every year we've had a few times where the popular vote does not correspond to the president of the United States, the elected person. And that has, is part of this equation. Bottom line it for us, though, in your estimation, do you think that the problem is significant enough for the justices to side with the electors in that it hasn't made a difference, and it likely won't make a difference. You can make the argument, oh, well, if it's a super close election that one elector in one state could, come on. The odds are way against that. Wouldn't it be safer for the justices to keep status quo?
That's a good point. Ultimately, we're going to have to see, what they decide, whether the, states' rights prevail argument. But, we have to, what you said about the Electoral College, some would say that the founding fathers didn't trust the people. So that's why they had the electors. But there's been a big movement for people, for the popular vote to count. And I'm a strong advocate for that. I think we should get away with the Electoral College and let the people's vote count. Each vote should matter. Each vote should count.
Yeah, Seth, because now we don't trust the electors. We trust the people more.
Well, I concur. I think that when you have a situation where it's happened a couple of times in modern political history, that the popular vote is different than the electoral vote, and then you take a look at the arguments here, which are fascinating constitutional arguments. Justice Ginsburg's question about, does it really matter, not only cuts to the core of how it operates in this case, but the system overall. And some states are really starting to look at following the popular vote. So this case definitely matters, and it's a big deal, but it also raises larger questions about how our democracy should be operating in a presidential election. And that's why it's so great when you have this unintended consequence of the door opening and the light coming in with everybody hearing this, that we're all getting a fascinating civics lesson on United States presidential elections.
Yeah. And the court as well, for a lot of people listening in for the first time, hearing these arguments. It's fascinating indeed. Joining me to discuss what we've heard today, Seth Berenzweig is in the state of Virginia, a constitutional expert, and Kelly Hyman comes to us from Denver, Colorado. I want quick thoughts before we take a quick break here, just on what we heard here. Seth, to you first, what stood out with these arguments?
Well, I thought counsel for Baca did a very good job. I found him to be, frankly, a bit more persuasive and a little bit more agile and prepared for some of the intricacies that were set forth in the questions presented. The only thing that I think he missed an opportunity on was the question with respect to personal tangible harm. And I think that the only area that he missed was to point out that this isn't just a case about $1 for nominal damages. It's a case about deprivation of freedom of political speech and expression under the First Amendment. So I think that was something that was a bit surprising. But overall, I thought that counsel did a very good job, and I think it'll be a close call.
Kelly.
I tend to agree that both counsels did an amazing job and really advocated their point, was very clear and concise. But some things I would have to disagree with. I thought that the Colorado was much more persuasive in the arguments, because if the fact that you are going to throw away the will of the people and let the elector decide whoever they want, then you're basically not counting people's vote. And I think that would do a severe harm to the people and also to the voters. But I think it's going to be very close. And ultimately, we're going to see what the Supreme Court decides to do.
Yeah, it's fascinating. Both sides basically predicting chaos if the justices go against them. We're going to take a break and discuss that and much more when we return. Joining me from Virginia, attorney Seth Berenzweig, and in Denver, Colorado, attorney Kelly Hyman have been listening in with us this morning. Let's wrap up Baca versus Colorado and the Washington case, Chiaflo, Washington. Bottom line it for us here. This is all about politics, right? It's the political process, but yet, ironically, it has nothing to do with a political party. When you look at the justices, you can't say, well, that they're going to definitely come in because it's the right side or the left side. This is a different issue. It's about the process, and it would affect both sides moving forward. We don't know how it would affect the elections moving forward, if at all. So, in keeping that in mind, Kelly, which way do you think this is going to go, and what would be the justification for either the right or the left of the court to side one way or the other?
Right. Well, one argument would be states' rights. So basically, you leave it up to the state to make the determination on what they feel if someone needs as electoral to make some kind of pledge, or basically saying that they are going to stick with the popular vote. So it's ultimately going to be the power of the people. Their vote is going to count or matter, or they're just going to have the electoral to do whatever they want to do. And so I think it's going to be a very close call on this one. And so we'll have to see what ultimately happens.
And Seth, it's individuals' rights as well.
Absolutely, individuals' rights as being teed up under, for example, the First Amendment for freedom of political expression. And, I think Justice Alito's question to the state as to why they couldn't just make it clear as to what the litmus test is, as opposed to just leaning up blankly on a power of appointment, was something that'll be very telling. But I think we agree that it's going to be a very close call. And it's also fascinating just to look in retrospect, just for 1 second, about the last 2 days of oral argument before the Supreme Court. Yesterday were the cases of Mazars and Vance against the president. That's something that has presidential political implications, things related to the election. Today we're talking about something that's also directly related to the presidential election. The Supreme Court tends to say that they're allergic to politics, but unfortunately for them, they're a little bit in the midst of it right now. So an important decision, and will be a close call.
Absolutely. All of the arguments have been fascinating over the last 2 weeks, 10 arguments in all. What about this process? The idea that, for decades, people have been knocking on the door, asking the Supreme Court for access, either audio, live audio, or even cameras in the courtroom during these arguments. How do you think it's gone? I mean, nobody got hurt here. It seemed to actually go very well. There was, yes, one flush of a toilet, but otherwise there weren't any technical issues, and the American people were able, if they wanted to, now to see and feel the process as it was happening. Kelly, do you think that this will make a difference moving forward? Is there a chance that this may be a small opening?
I hope so, because I really think it's important for access to the people to kind of hear this and kind of know what's going on, especially with, technology, whether they have, people there, how they're going to do it. So I'm hoping that it does open the door, because this is great to feel like you're there. And it's very exciting. So I'm hopeful and optimistic that this will change and that this will be some kind of process moving forward.
Seth, you're in D.C. Any chance here? At one point, Justice Breyer once told Roger Cossack, over my dead body, will there ever be a camera in the United States Supreme Court? Well, there are microphones there recording them now, and they just replay it on the Friday after arguments. Any chance we'll get live audio?
Well, I don't think that they're going to be opening their doors that much anytime soon, which is why I agree this has been such a very helpful public process. There's been so much activity and so much controversy regarding presidential issues and matters of constitutional concern, and people really go back and forth in social media. This is a unique historic opportunity for America to be able to open the doors and shed light in terms of what's happening with these issues that are so central and critical to our democracy. So I think it's fantastic, and I think that hopefully it's a trend that continues.
The bottom line here, though, Kelly, is that the justices have not want this historically. There's never been a real debate about it. It's just been people asking, and the absolutely no was the answer. So even though, let's fast forward post-coronavirus, they're back in chambers here. Is there even a process to get this open up? I mean, it seems to me like this door's going to slam shut the way it was before, and 20 years from now, the argument is still going to be within the confines of the courtroom.
Right. Well, I guess I'm always, optimistic. I always like to think of like it's half full, so that maybe through this process that they realize that there is a way to do it, to give people more access, because I think it's really important that the American people hear this and they have the access to do this, and they deserve it. So I'm hopeful and optimistic that this will open up the eyes and maybe keep the door a little bit cracked for the possibility that it can happen moving forward.
Seth, quick final thoughts on the whole process over the last 2 weeks.
Well, let me just say that this breaking news regarding the passing of Amy Stevens is very sad. This issue of whether federal civil rights legislation encompasses transgender discrimination is a major historic question in the realm of employment law, and it's going to have a huge impact from coast to coast. But it's been a huge week, and it's been a huge week not only in terms of seeing where we go in terms of employment law and the scope of civil rights, how the upcoming presidential election is also going to be impacted, as we've discussed today. So we'll see several decisions and history in the making as we see what happens over the next few months.
All right. Indeed, well said. Seth Kelly, thank you very much for joining us.